Hi everyone, myself Arindam and I'm a legal intern at LEXIS and Company, and today we'll be discussing on the topic of res subjudice of the Civil Procedure Code. So res subjudice as written in the stay as a suit in the Civil Procedure Code, that is section 10 of the CPC. So let's get started. So no court, what is written in this particular section, we'll first go through that, and then of course we'll go through the alteration of the section, the scope and the objects, and then we'll get into an illustration, and then we'll understand what is the relief, and after that we'll think of the what will happen to the previously instituted suits, and what we'll think about the previous shall not proceed with the trials. So let's get started. Okay, so first let's get the the bare act definition of res subjudice. So no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between parties with the trial of the suit whom they or any of them claim litigating under the same title where such suit is pending in the same or other court in India having jurisdiction to grant the relief claimed, or in any court beyond the limits of the India established or confirmed by the central government and having like jurisdiction or before the Supreme Court of India. Now what is the explanation? The pendency of a suit in a foreign court does not preclude the courts in India from trying a suit founded on the same cause of action. Alteration in this section. The word proceed with the trial has been substituted for the word try. The words except where a suit has been stayed under section 20 which occurred at the commencement of the corresponding section of Code of 1882. The words for the same relief which occurred after the words previously instituted suits, and the words whether superior or inferior which occurred after the words any other courts have been omitted. The words litigating under the same titles are new. So that was the alteration of the section. Now the scope and the object. So the present section of CPC provides that where a suit is instituted in a court to which the code applies, the court shall not proceed with the trial of the suit. The matter in issue in the suit is also directly and substantially in issue in a previously instituted suit between the same parties. The previously instituted suit is pending in the same court in which the subsequent suit is brought, in any other court in British India where the superior, inferior or coordinates, or in any court beyond the limit of British India established or continued by the Governor General or Council or before his Majesty in Council. Thirdly, where the previous instituted suit is pending in any of the courts mentioned in clause B or C, such courts is a court of jurisdiction competent to grant the relief claimed in a subsequent suit. And the object of this section is to prevent courts of concurrent jurisdiction for simultaneously trying two parallel suits in respect in the same matter in issue. Now we'll be diving into the illustration. So suppose B residing in Kolkata as an agent A at Calicut employed to sell his good there. A sues B in Calicut claiming a balance due upon an account in respect of dealings between him and B. Now during the pendency of the suit in the Calicut court, B institutes a suit against A in Calcutta for an account for damages and for damages caused by A's alleged negligence. Here's the matter in issue in B's suit is directly and substantially in issue in A's suit. Further, both the suits are between the same parties, therefore the court at Calicut is a court of jurisdiction competent to grant the relief claimed in B's suit. The Calcutta court must not proceed with the trial of B's suit, and the suit in Calicut court, being the one instituted prior in point of time, should alone be proceeded with it. But if A was B's agent at Pondicherry instead at Calicut, and the suit was brought by him in the Pondicherry court, the Calcutta court would not be precluded from proceeding with the trials of B's suit, because the Pondicherry court being a foreign court, the provisions of the section applies those though the relief claimed in the second suit may not be same as that claimed in the first suit. Now the relief need not be same. The corresponding section of the Code 1882 contained the word for the same relief after the word previously instituted suit. Hence it was necessary to the application of the section not only to the matter in issuance, the second issue should also be directly and substantially in issue in the first issue, but the second issue must be for the same relief as they claimed in the first. Those words have been omitted in the present section. The effect of omission is to render the provision of this section applicable even though the relief claimed in the subsequent suit may not be same as that claimed in the first suit. What is now essential in the identity of the matter directly in the substantial in issue? The identity of the relief claimed is immaterial, and it has been held by the High Court of Patna following a decision of the Calcutta High Court that this section does not apply to a claim relating to a period subsequent to the claim of the former suit. So this is all about res subjudice, section 10 of the Civil Procedure Code. To view such more videos, please do check out Lexcliq and our playlist. And thank you for watching Lexcliq. Please do subscribe to our channel.